everyone to tonight's meeting of the Albany County Legislature's Law Committee. First item of business on the agenda is take roll.
Sure, Mr. Chairman. Kuhn.
Here.
Reedy.
Here.
Feeney.
Here.
LaRilliard. Here. McLaughlin. Here. Slotsky. Ricard.
Present.
Bergdorf.
Here.
And Whalen. Here. You have a quorum.
Great, thank you. First item of business is approving the minutes from the previous meeting. Can I have a motion to approve those minutes?
Motion.
Second.
All right, and that's from our July 24th meeting. All in favor of approving those minutes?
Aye.
Any opposed? Great, that carries. So we're going to take items 13 and 14 out of order. So we'll start with item 13, which is amending the 2024 Albany County budget, Youth Violence Prevention and Response Community Initiative. And I believe we have Ms. Amanda Wingle here tonight to present on this item. Ms. Wingle, you want to just introduce yourself and say
Absolutely.
your title and everything?
Yeah. Good evening, everyone. My name is Amanda Wingle. I'm the newly appointed director of the Crime Victim and Sexual Violence Center. It's nice to see everybody again. So
Great.
Yeah.
Thanks for coming. And you want to just talk to us about this item?
Yes, absolutely. So this is an initiative that's aimed at preventing youth violence in the community by providing support to both youth and families. We're working to reduce recidivism rates by working with youth that are already involved with the justice system and providing support to them and their families. So that it will largely be determined by needs assessments and surveys that are done with the families to determine what the needs are. But some of our ideas are to work with schools and after-school programs to provide things like techniques for emotional regulation, conflict resolution, communication skills, also potentially services for parents, parenting classes, cooking classes, all different kinds of things are on the table right now depending on what the community needs, but the goal is to really provide support for the family as a whole.
Fantastic. Does anybody have any questions for Ms. Wingle? Okay, can I have a motion?
Motion. Full second.
All right. All in favor of approving item 13? Aye. Any opposed? Great. Thank you so much.
Thank you all.
Thank you.
Okay, item 14 is authorizing agreements with the New York State Division of Criminal Justice Services regarding aid to defense grant funding and amending the 2024 Albany County budget. We have Albany County Public Defender Judge Herrick, and then does everybody else want to just introduce themselves quickly?
Oh, Steve Herrick, Albany County Public Defender.
Tina Sodi, Albany County Alternate Public Defender.
Thomas DeBose, Administrator, Albany County Assigned Counsel Planner.
Great, thank you all for being here. Do you want to give us your presentations?
Thank you, everyone. This is a application for, it's an RLA from the 3 indigent criminal defense providers requesting legislative approval to accept grant funds from the New York State Division of Criminal Justice Services in the gross amount of $1,439,718 to administer. It's a 2-part grant: aid to defense for discovery reform and aid to defense for supplemental programs, and to authorize budget amendments for the 3 offices for the 2024 budget. There's no cost to the county. This is all state money. Any proposed hires by the Public Defender's Office, we have 2 proposed for the 2024 budget. The people hired would be notified that this is a grant fund and that their positions are not guaranteed to continue should the grants not be continued after the 2 years that there will be in place. Ms. Sodi has submitted a memo that I'd like to just make note that the public defender joins in relative to one aspect of the distribution of the funds for the supplemental part of the grant, which includes recruitment and retention specifically. The Public Defender's Office for the discovery reform requests approval for purchase of hardware and software training, and specialized services, including trial presentation services, video transcription services. With all the discovery that we get that is now in video form, we need to get the dialogue and the videos transcribed for easier and continued use and discovery. And we have a position for a new forensic attorney. This would be a unique position requiring a special skill set of forensic science as well as litigation. And it's a top-level position on our salary schedule and includes the salary and 53% fringe. The supplemental part of the two-part grant, we are also requesting to have the budget amended to allow hiring of a new IT discovery tech position, and this is a lower-level position plus fringe, and for retention purposes, recruitment and retention, we are requesting that we be allowed to distribute money in accordance with the substance of the grant in the form of stipend to criminal defense staff.
Great. Anything else? Does anybody have any questions for the witnesses regarding the agreements or the budget amendments? Yes. Go ahead.
I get what concerns me is, you're bringing on new staff, you got all these different services you're going to provide, and you say, paperwork says that you expect it to be recurring, although this just goes to 25.
We're treating this as a 2-year grant. We don't know whether it will be continued past that. So any hires, the 2 hires that we're proposing, will be notified that there's no guarantee of a continuation of funding for those positions. So should the funding disappear, and we would then reevaluate other methods of continuing a position and funding it, and if we couldn't, then that position would be deleted, and the person would have been on notice from the moment of hire.
Is there some way we can be proactive and to ensure that it's recurring? Because it seems to me you put it in a lot of resources. I'm sorry, it's air conditioning that affects me. Put it in a lot of resources that could really serve, that have great outcomes. And why would you want to lose that?
I think we have been proactive. I've been here almost 8 years. The office has almost doubled in size. And I'm sorry, yes?
This happens all the time, so this this issue is a recurring issue.
It is.
Oh.
It's ongoing, and we have 3 balls in the air at all times, and we've been lucky so far. So.
Yep. Thank you.
If I may, I don't, and the grant that we currently are speaking about, these are the funds that we should have received last year.
Right.
The governor passed that in last year's budget for 2024, so we should have technically gotten it in April of last year. Obviously, DCJ is over 1.5 years behind to provide these funds to the defending offices, even though the district attorney's offices have been receiving it for the past few years since discovery reform was implemented. This is the first year that we're getting it. The promise for next year is already there because that was passed in this year's budget for 2025. So technically, these funds are for last year. This year's funds we haven't even seen yet. Next year's funds will be addressed in April of next year once the governor's budget comes about again. So as always, we are behind. So because we are behind everything that we're doing, technically we're still ahead of the game because of the delay and process for the funds to get to the counties as always. And Since the DA's office has been receiving these funds for a greater time than we have, and they haven't taken away theirs, I don't anticipate ours being taken away either, because the constant lobbying from all the defenders throughout the state has been that argument that we are on the receiving end, and if we want to have equality amongst both offices, since we are on this, technically doing the same exact job, just adversaries, one should not be treated differently than the other.
There, but for the grace of the state budget, go we.
Ms. Whalen.
I just have a ministerial question. So you have separate budgets, right? The public defender. So how will you it's probably in
It's
here.
already been apportioned.
So who will get, if you receive it, who will get which, what will you get, what will you get?
The portions, so Judge Herrick, do you want me to say it? It's fine, I have it. So with respect to since there are two different grants, the aid to defense, the supplemental for criminal matters, Judge Herrick's office, Public Defender's office will receive 71% of the $719,859. My office will receive 21%, and Mr. DeBose's office will receive 8%. With respect to aid to defense discovery reform for the same total amount of $719,859, the Public Defender's office will receive 60% of the grant, my office will receive 20%, and Mr. DeBose's office will receive 20%. That has been the breakdown.
And so when the money comes in, it will be, someone will be able to clearly give you the checks for those amounts.
Yeah.
It won't be like confusing to them or,
That's great. The confusion's been taken out of it.
good. So you know what you'll be getting. and
Correct, we know the exact amount as to what we're receiving.
Thank you.
Ms. Berger.
Thank you. Much has been said over the years about discovery and different databases, and I know you're all wrestling with it, as are law enforcement agencies and the DA. Is there any more effort to have a common database that everybody can share and draw upon?
There's growing conversation about that. That would take state responsibility and rather away from the counties to do that, and to have something like DCJS has with the criminal histories of people in New York State and elsewhere, or DMV has the ability to do that, and it would take something that large and a lot of state money, but it would probably in the long run cost a lot less.
So are we still running a separate database, and the law enforcement agencies are running a different database? Can they transfer stuff to you? Is it portable?
That's why we switched to, last time I was here, Axon, so that we have a flow that will come directly from the DA into our software.
Okay. Well, I guess my question was, you're at the back end of the process. Does the discovery disclosure stuff, well, no, you're not at the back end of the process. You get the same stuff the DA gets. So, but is that coming from law enforcement agencies?
We get it from the DA, we get it from the law enforcement agencies, and then in turn, we have reciprocal discovery so that we have to provide the DA with discovery.
Okay.
So, Mr. Bergdorf, I think if I am understanding what you're saying, we do have a universal system that at least that we will soon have. The law enforcement uses Axon. The district attorney's office has been using that. We are the last in the group to now acquire that software and technology. And the funds that we are we're asking for now are for discovery. That's what one of the portions, at least for my office, that's where it's going to go, so that all agencies are now in the same system, so we can actually open these videos without difficulty.
Yeah, so you're on the same enterprise software.
Yes.
That's great. That was really the essence of my question. Thank
Any
you.
other questions?
Yeah.
Mr. Griffin?
Thank you, Mr. Chairman. All this video coming in, you have to go through it all?
Yes.
And then you have to transcribe it all?
We don't have to transcribe all of it, but we get in a traffic stop, you've got 5 officers with 5 body cameras, and we're looking at it from different, yes, it's a lot of time.
Well, how does that work in court? Do you have to go to the tape all the time, or you can use the transcriptions, or a combination?
A little latitude here, we're getting a little far afield, but
No, it's kind of interesting.
The courts have just upgraded their technology in the courtrooms. In fact, they're giving on-site tours of it as we speak. If you wanted to stop over to the county courthouse or the judicial center, you can see it. They've got the new technology that they're showing to the different offices right now. So we need to get educated. That's why some of the monies that we propose to use will be used for training, so that we'll have the same capabilities as the district attorney's office has had up to this point in time.
Thanks, Chairman.
any other
Mr. Graham,
questions?
the new technology does have transcription capabilities, so it does make our life easier on that part, and then you have the
Just
ability
go
to
through
prompt
it all.
video.
You can read it.
Yes.
Yeah, that's what I wanted. Thank you, Mr. Chair.
Yep, great. Any other?
Make a motion.
Mr. Feeney? Reedy? All in favor? Aye. Opposed? Great. Thank you all for being here.
Thank you.
Okay, so now we're going to go back to the top of our agenda, and so item number 2 regarding proposed local law E, I understand is being tabled at the request of sponsor. Item number 3, requiring programmatic information requests for legislative action and codifying existing practices, I understand that's also being tabled. Now, so that brings us to item 4, public hearing on proposed local law K for 2024, a local law of the County of Albany prohibiting the use of employment promissory notes and other similar provisions. I believe Ms. McLean Lane is here to discuss this proposed local law.
Thank
Have
you,
the
Chair.
floor.
So this legislation came about due to a constituent who was working in a salon, making $14 an hour, and a condition of employment was to sign a contractual agreement with the employer that they would not leave within a year, and then they had, otherwise they would owe that individual or employer $5,000 for training. This training was done on site. This training was not in any way, shape, or form, it was done on paying clients. This is happening all across the state, actually. And, you know, people who are applying for jobs, it is up to the employer to train them. It is not incumbent upon the employee to be restrained in a work environment and not have freedom of movement out of that work environment because they have received some training. And unfortunately, though the state and federal government are moving on this, the fact is to get intervention from the state or federal government on your individual situation takes far too long. So this is just to prevent these things from going forward. If you want an employee, well, you train them. And you don't restrict them to your employ for a year or beyond a year simply because there was some training involved.
Any questions about this, Ms. Whalen?
Will the people be reimbursed by the employee if they leave within a certain amount of time after they're trained?
Reimbursed.
Reimbursed for the money that they expended on training this person?
No, because if you are going to train somebody, that is incumbent upon the employer to train them. Now, the vast majority of these things are not training, bona fide training that they have spent money on. It's services that are done on paying clients. It is just a way of trapping people into employment.
So it's like a covenant not to compete is what you're looking at?
Yes, you are 100% correct.
And so does this apply just to hair salons, or are we applying this to doctors' offices,
We're
lawyers?
applying this to everywhere. If you want to, you cannot make an employee be stuck in employment that they are not happy with, whatever the situation is, just because you have provided some training. that is incumbent upon the employer. So this is to stop this from going forward. It is a way to trap people in employment. It is, sadly, it's very unfair.
Does the, I'm not sure if I can't remember if the proposed legislation also abrogates like a mile radius of where you.
No, this isn't a non-compete, a traditional non-compete. But that is a very good point. No, it does not. It's not a traditional non-compete. This is about a training reimbursement agreement. I've trained you, so therefore, if you leave, you've got to pay me back.
Mr. Ricardo.
Yeah, just a follow-up, because I was going to actually mention that. Sometimes when they have a general contractor, actually, they have non-compete clauses with their subcontractors. So I don't know, or maybe the attorney's
This actually excludes any union agreements.
Okay.
That is not engaged in this. Those are those contractual agreements are outside of this.
Okay.
This is just straightforward. I'm going to hire you, but a condition of employment is this.
Okay.
If you leave within a certain amount of time, and I have trained you, you owe me that money. And believe it or not, these things are actually in litigation in Albany City Court, Colony Court, Albany County Court. They have been in all of these courts, and it's unfortunate. But the thing is that it restricts freedom of employment.
Right.
And additionally, a condition, you shouldn't have a condition of your employment. You know what I mean?
Sure.
Okay.
Thank you.
But great questions from both of you.
I'm full of good questions, aren't I?
Somebody trains somebody, even as far as, might be sending them to a certificate school for some kind of thing, or our sheriff sends them to an academy. And they go to another police department, say, our own sheriff does this. And then the sheriff goes after, not
There are
the
bargaining
person,
agreements that
not the person,
oversee
but
that.
the other
This is outside of union bargaining agreements.
Why doesn't it apply to the union?
Because union bargaining agreements are agreements that go into, people are aware of them up front. That's a bargaining agreement that's collective bargaining, a large group of people, not, just an individual employee.
So it wouldn't affect the sheriff, but say in another instance where somebody, I don't know, plumbing business, and they send them over to Tux Valley, get schooling, and the employer pays for that, and that happens all the time. And then the person goes and works for another company. So that person...
They paid for the...
No, the employer paid for them?
If they are willing to hire somebody that's untrained, and they say, okay,
Give them a
we'll train you
chance.
and I'll pay for the training. But you can't make that a condition of employment.
To
You
not
can't say
even
that you have to pay me back now.
But if they put them, this happens in the real world where, for like, I know, air conditioning, plumbing, electricians, they go through...
But usually there's collective bargaining agreements
No, I'm
that
talking about
oversee a lot of those
private
things. But also, if they want a well-trained workforce, then, this should not be a condition of employment.
Can I just add something to that?
Yeah,
I'm still waiting to get recognized, so.
Just from I just want to follow up, and it's the chair's decision, but I know a lot of times in the private, as far as plumbing is a prime example, they'll give an individual a bonus after, let's say they were there for a year or two. But that's what I've seen here. But I just wanted to...
Incentivize.
All right, Mr. Bergdorf.
Thank you very much. The state of New York, Albany County enters into these agreements all the time. State of New York will send people to college with the condition that they serve as teachers or as police officers. Evidently, that's hostage taking under this
No.
definition. Excuse me.
Because those are collective bargaining agreements.
Collective bargaining agreements who, with students? College students?
I apologize, please go ahead, Mr.
Okay. Also, let me ask you a question. Will there be an exemption for non-union people with apprenticeship training programs, of which there are many of them certified by the state of New York? So you're carving out an exemption for the unions.
You are very welcome during the committee process
hold on.
to add conditions.
No, I'm asking a question.
Yeah. Well, finish your question and then answer his question, if we can do it.
I
like that.
apologize.
That would
And I
be
apologize to
more
you,
orderly.
Mr. Brinter.
Is your question finished?
No, my question was, I didn't get an answer. Does this apply to non-union contractors who have apprenticeship training programs that are approved by the State Labor Department? Or is the carve-out only for unions?
Okay.
That's the question.
And I appreciate your kindness, and I apologize for interrupting you. That is a very good question, and I think this is absolutely what the committee process is for, to bring up points that you have brought up and that your colleague, Ms. Lockhart, has brought up, to help us better hone this legislation.
Well, I mean, we have the airport. We had somebody here talk about the training program to get into the airport maintenance program, where they're bringing people in and they're paying for them with the condition that they go into the private sector. Are we going to be doing away with that stuff, I guess?
I don't think we are, because state law supersedes county law.
What does that have to do with the airport and an agreement with Hudson Valley Community College and the airlines at the airport? That's not state law.
Okay, well,
I'm
you had
talking
just
about-
said state programs, so that's what I was referring to.
No, I talked about state programs before, which is the education. Our sheriff, he enters into anyone who goes to a Zone 2 training academy. If Albany County pays for them, and then they laterally move to Bethlehem or Colony, Bethlehem and Colony have to pay the county back for the training costs associated with the Zone 2 costs, because that's something that they all agreed to. How is that perfect?
That doesn't supersede that, because this is not requiring the employee to pay back the employer.
All right. Once again, we talk about making changes to this thing before it goes to hearing, before the committee has really had an opportunity to ask detailed questions. I get a lot of other questions, which I guess we'll ask at a different time. But it sort of troubles me that we are changing how 25,000 businesses may be regulated in Albany County because of a $14 an hour male employee. That's what we're basing our policy on. I don't see this as an issue. I've been in government for 40 years. I've never had anybody come up to me and say, oh my God, my restrictive employment agreement, it's killing me. And I think, to be very honest with you, and this will be the last thing I'll say, this is going to be like, everybody thinks raising the minimum wage is the panacea to get everybody more money and, economic advantages. What you're going to do is you're going to have employers say, I'm not going to train anybody anymore. You want a job? So instead of coming here and we will train you, and we will train you to be a $100,000 a year airport mechanic, why would anybody train somebody to do that if they're going to go down to LaGuardia or JFK? Why would you do that?
Okay.
So anyway, but that's...
This is a public hearing, but I am also, Mr. Bergdorf, I believe you have my personal cell phone number.
Yep.
I've called you on occasion before.
Yep.
To have lovely conversations about adjustments, et cetera.
Yep.
And I believe this is what the committee process is for, to
Okay.
ensure that everybody has input.
Yep, Mr. Reedy.
Well, one of my questions was answered. We are voting just to move this to a public hearing. But I will say, actually clarify. And I will say, I think some of the points my colleagues brought up, Mr. Bergdorf and Ms. Whalen, actually think they do merit a lot of discussion and thought here. So I do think there may be differences beyond just our union apprenticeships between, legitimate training programs and what I do think this law is covering. But I will say, a long time ago, in fact, my birthday last week, I'm pretty old. I know I look young, or many people tell me that.
Happy birthday.
Thank you. And maybe I was fishing for happy birthday, so thanks, Ms. Lockhart. I actually entered into a job with a very similar arrangement. I had a 2-year non-compete clause. So going into, a new job where, it was a sort of on-the-job training, but, to be honest, the job I was ended up going for, the actual studying for me to be qualified for it was all meant to be done on my own time. And, the on-job training, more or less was working the job. And, the non-compete, I didn't have a, something to pay back if I had left, but I had a 2-year, I think it was 2 years non-compete clause, which basically meant that, the job that I was working, ostensibly being trained for, like I can work for nowhere else locally. So, I do think there are many fields where I do think this stuff is a huge issue. So, I'm glad this law is being introduced. I have confidence in our committee process, but I do think some of the points brought up are good ones.
May I respond to Mr. Reedy?
Sure.
So I was actually subject to a non-compete. I managed a national chain of cosmetic dermatology centers. I wish I could say I had Botox now, but I do not. And I was restricted from working within 125 miles of the borough of New York in any field related to cosmetic dermatology. Many people enter into these agreements and they don't realize what they're signing. Now, I take very seriously the comments by my minority colleagues because they are well-intentioned. And I would like to hone this, whether it be a descriptor being bona fide training that, costs the employer money or something of that nature. I am happy to make changes. And I trust our committee process will be helpful in doing that. And I apologize, Ms. Whalen, please, you did have a question.
Well, before we circle back around, I have a few comments that I'd like to make. The concept of covenants not to compete has been invoked a few times. I'm not understanding what that has to do with this.
So non-competes are actually somewhat similar, and I think that's why Mr. Reedy brought it up. So the federal government is trying to massively restrict non-competes, which touch on these type of covenants. So what happens is you get restricted to a job.
Oh,
And
I
can't
know
leave.
what a
Yeah,
covenant not to
so-
compete is. I don't see how this is relevant to it. There's nothing in this about that.
No, there isn't, and that's true. They are similar to, because they restrict you.
But it's not in this law.
No, it is not, and that is absolutely correct, Ms. Lockhart.
Okay, the other thing, the anecdote that you brought up, do you know if, in that example, the employer had the employee sign this agreement, did the employer then attempt to sue the employee for breach of
Yes,
contract?
actually in 3 separate courts.
Okay, and what was the resolution of that? Did a court?
so-
Hold on.
Oh, I'm sorry.
Finish my question. Did a court find that contract was enforceable?
Yes.
And they required the employee to pay damages for breach?
So what happened was, I'm happy to share with you, this employee was, the contract actually said to sue in Albany County, even though they worked in Schenectady County. So I pointed that out, and then that was tossed. And then they sued them again in Colony Town Court. That didn't go very well. Then sued them again in Albany City Court.
Well,
And they
sued them in Colony that didn't go very well. What is that? What do you mean?
It means that
can't sue
I
somebody
don't know
twice
if
for
it
the
got
same thing.
lost. I do know the ultimate outcome, and I don't want to impart information that I am not 100% clear on, and I apologize for that. What ultimately happened is that in Albany City Court, this individual ultimately, after paying thousands and thousands of dollars in legal fees, which also happened to multiple colleagues of hers, she ended up having to pay, I believe it was half the amount, $2,500, but the fighting over this ultimately violated the minimum wage law because they had to leave that employee because there was vaping going on. There was, this person's a cancer survivor, vaping, lots of chemicals. That individual finally said, I paid for this allegedly training, not paid for, but am obligated to this provision of training. But the problem is that it was terrible working conditions, which they were restricted to. So they left that employee. And then what happened is obviously then the lawsuit started by the employer.
Maybe.
And ultimately, it was,
all the details of that.
they ended up for less than 6 months, I believe it was, of employ at $14 an hour, having paid thousands of dollars in legal fees. And in addition, I believe it was a $2,500 award, but I am more than happy to email everyone who has questions the exact amount, but I believe it was about that.
Okay. There's a thing in the law that basically, sometimes bad facts can make bad law. It means like you've got
I
a
agree.
situation where there's some sort of egregious fact pattern and ends up making a decision, and then that decision is applied to more typical. No doubt that the situation you're talking about sounds terrible, but whether or not the answer to it is to sort of ban all in professional settings where there's a more even sort of bargaining position. Oftentimes, someone is hired and they're given a signing bonus, and that signing bonus is contingent upon the person working at the company for some period of time. And that happens all the time. It happens with attorneys. I'm sure it happens. I have to know a little bit more about, but I'm sure it happens in all sorts of other industries. So if you hire an attorney and you give them a signing bonus and you say, but that's contingent upon you working at this firm for a year or two, I think that would be prohibited under this.
I don't believe so, because
Well,
it's
why
not a
not?
signing bonus, it's not training.
But then I think we're going to have to revise this because
So it's
while
not training.
hold on, let me just finish. While training is talked about, it isn't limited to training, right? If you look, it says employment promissory note means basically any instrument that requires a worker to pay their employer a sum of money if the worker leaves such employment before the passage of a stated period of time. Now, there's a separate sentence that says this includes, for example, training, but it isn't limited to training. So my concern is that the sort of conventional signing bonus scenario would be prohibited by this.
Well, then, I'm very happy to amend it.
Okay.
That would please the committee.
Allison, would you consider, with all the things that have been raised here tonight, to maybe table this so we can kind of...
Of course,
Okay.
of course.
All right.
All right.
Why don't we do that and try to address some of these issues?
Oh, absolutely. And I appreciate everyone's comments, and I appreciate their insight. This is just filed starting point. I knew there would be a lot of conversation about it, but I also like having everyone's input.
Mr. Chairman, maybe just a comment before you take it.
Briefly, but
I
briefly,
would just
please.
ask you if you could, when you look at everything that's been said and you look at the law that you're proposing, really think about the small business people in our county especially. I think it's going to be really cumbersome. They're having a tough time getting people as it is. They spend a lot of money on training people, schools, different things, and just really consider that too.
And one thing that did come up, and I agree with you, Ms. Lockhart, is separating training from bona fide training. Bona fide that the employer pays for.
Yeah, okay.
Okay, so I think we're going to table this subject to
That's
some
fine,
further
absolutely.
consideration. Great, well, thank you.
Thank you, and I appreciate it.
Okay, so then we're going to move on to item 5, which is, is this happening? Item 5 is table, request of sponsor. Number 6 is tabled. And then, so that brings us to number 7, which is local law I for 2024, amending the county code to update the tattoo code provisions. I believe Mr. Fine is the sponsor.
Do you want me to sit there?
It does, you don't need to sit there.
So we had the public hearing for this last night. Essentially, it modernizes the tattoo code, simplifies compliance, and the biggest piece is it removes some obstacles that exist to hosting conventions, tattoo conventions, primarily the requirement that there is a sink at every tattoo station. Now, medical grade hand sanitizer is allowed. And we came about this language with collaboration with the health department. So they're supportive of this.
Great. Yep. We had a public hearing and people spoke on that. Mr. Bergdorf?
I think it's a tremendous idea. I had mentioned to your 2 people who spoke last night that I have friends down in Rockland County, and certain dates draw me to visit them. And they actually have tattoo conventions down there at Rockland Community College, where there are hundreds and hundreds of tattoo artists and some of the biggest crowds you've ever seen. And that's an economic driver for their county. So, you know, sometimes a little thing you do, and in this instance, it's a good thing, can really add to the economic development efforts for the county. And I'd like to be a co-sponsor.
Great, thank you.
Okay. Yeah. Anybody else? Mr.
I'd like to co-sponsor it also.
Okay.
Thank you, Mr. Chair. Yeah, usually businesses cringe when government regulation comes along, but we heard last night, these 2 guys really love the idea. It's going to improve the tattoo business, so I say hooray to see them fine, because it's where government, this is when government works. So congratulations. Yeah, put me on.
Add me. I will also sponsor Mr. Bergdorf to get the first tattoo at our first convention here.
I showed them the one I want. I already did.
I said last night,
They have stick-on ones?
it'll be an
I have
airport one.
stick-on ones.
I said last night, it'll be an
Can you
airport.
add me, and can I move it? Approve it?
Sure. All right, motion.
I just wanted to
I'll second and add me.
scales of justice.
Everybody's in.
Everybody's in.
Okay, all in favor of local law I? Aye. Aye. Any opposed? Okay, great. Thank you. Next item is table, local law J, that's tabled. Okay, 9 is,
Is that table, we're still waiting for the governor to sign? Thanks.
okay. 9 is, okay, we just dealt with that, that's that one. 10 is, is this tabled? Oh, local law L is also tabled. Oh, okay. So item 11 is public hearing on proposed local law M, which is amending the county code regarding the welfare and safety of pets and vehicles, commonly referred to as the PAWS law. Mr. Dini, I believe you are.
This was tabled last month. We're trying to get this out for a public hearing. I understand there's been some changes made. I refer to council.
Yes, there have been some changes made. The fines have been lowered from $500 to $250 for a first offense and from $1,000 to $500 for any subsequent offenses. The possibility of jail time has been removed, and also there has been a clarification that a pet in the passenger front seat, or well, the front passenger, whatever, that pet in that position is not considered to be in the immediate grabbable area, so they are excluded from the lap prohibition.
Just a question.
Well, hold on. Before I'll recognize you. Does anybody on the committee have anything they want to say about the PAWS law? So basically, if I understand it correctly, it primarily is going to ban people from driving with dogs or cats in their lap while operating a motor vehicle.
Yes, in their lap, on the dashboard, as the case may be. I mean, any sort of unsafe thing where the pet is not restrained but is moving about the cabin or otherwise on the lap and restricting actual motor vehicle operation.
And I also understand, to respond to certain opinions that have been expressed, that the county sheriff was one of the prime movers. The county sheriff's office was one of the prime movers behind this because they
Yes, it's my
saw
understanding
this
that-
and regarded it as a dangerous situation, correct?
Yes, it's my understanding from conversations with the sponsor that the sheriff does support this, and he will be speaking on it tomorrow at Public Safety.
Oh, Sheriff Apple will be? Okay, great. Now, just, Mr. Brown.
Yeah, thanks, Mr. Chair. The one question I had is, if you have a pickup truck with no back seat, your dog can ride with you in the front seat, because there's a lot of rural areas that have exactly that.
Yep, as indicated, if it's in the passenger seat, it's not a problem. That's been removed from the definition of.
So the immediate area thing, that was always the question, what does immediate area mean? And that's been, I
think that's been clarified.
Good. And nobody's going to jail.
You shouldn't have a dog in your lap while you're in your car.
Pulaski's gonna be very happy.
Yeah.
Buddy can ride the convertible.
Definition of lap dog.
Okay, so first thing, does anybody else have anything on this? Okay, then can I have a motion, or do I do amend first?
Yeah.
Okay, so I understand that we need to amend the date of the public hearing to
September 24th.
September 24th. So first, can I have a motion to amend the resolution to amend the date to September 24th?
I'll make a motion.
All right, Mr. Reedy?
I'll second.
Mr. Feeney? Okay. All in favor of the amendment? Aye. Any opposed? Okay. Now, can I have a motion to move this with the amendment to a public hearing? Mr. Reedy?
Second.
Mr. Feeney? Okay. All in favor?
Aye.
Any opposed? Okay. So that's 11. So number 12 is tabled pending the public hearing, and then we did all the other ones, so we are done. Can I have a motion to adjourn?
Motion. Second.
All right, all in favor?
Aye.
Great. Thank you so much, everybody.
Yeah.